Hi everyone, in this next series of videos we're going to focus on the Employment Rights Act, as it will now be known, having been granted royal assent, and discuss provisions around trade unions. Now, whilst these might not at present be relevant to many workplaces because there is no trade union presence, one initial issue to be aware of is that the thresholds and the requirements for getting a union recognised within an employer is going to become a lot more simple. So who knows, in the future trade unions may be coming to a workplace near you. The first change, which actually will affect all employers, is the right to a statement of trade union rights. So the Act will require employers to give workers written statements advising that they have the right to join a trade union. Now, essentially this is going to work in the same way as providing the statement of terms and conditions of employment. It must be given at the same time as providing that statement and at any other prescribed time. So that may mean legislation will require that every 2 or 3 years, for example, employees have to be reminded of their rights to join a trade union. So it's another piece of administrative paperwork that has to be given at the very start of employment. We don't know what the regulations will confirm in terms of the information that has to be included in the statement, the form that has to take and the manner in which it's given. So we assume it will be again in the same way as the contract, something either electronically or in paper being given to the employee. The suggestion is that that information will include a statement that an employee has protection against detriment and dismissal on trade union grounds, and the suggestion is that there will also be a financial penalty in the event that that statement is not given. Again, that will work similarly to the failure to provide terms and conditions of employment. It doesn't or should not bring the right to a standalone claim, but in the case of a failure to provide a compliant contract, an employee can tag that claim onto something else, such as an unfair dismissal claim, and be awarded either 2 or 4 weeks' pay. There was a consultation in October 2025. We don't have the final content of the regulations on what's going to be required as yet, but we do expect this one to be implemented in October 2026. So watch this space. We will have more information on the content of that statement, and it will impact all employers potentially with effect from October 2026. We will move on to the other controversial aspect, in my view, of the Act in the next couple of videos. This is on the right of trade unions to access a workplace. For now, if you need anything on this, the Employment Rights Act or employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.